From the Subaru of Gwinnett studio, this is Injury Insider with Derek Hayes. Injured in Georgia? Make the right call to the law office of Derek M. Hayes at 404-777-HURT. Injury Insider is presented by Status Home Design, your one-stop shop for all your home and gift needs.
Hello and welcome to Injury Insider with Derek Hayes on Business RadioX. We are broadcasting live from the Subaru Gwinnett studio in the Sonesta Gwinnett Place Atlanta Hotel. This show will answer legal questions and debunk personal injury myths with insight and expertise. For over 25 years, Derek Hayes has exclusively represented injured parties in Georgia. Now, he'd like to put that knowledge to work for you. My name is Lita Brooks, and it's my pleasure to introduce the star of the show, Mr. Derek Hayes. Good morning, Derek.
Good morning. Good to be here as always.
Yes, absolutely. Before we begin the show, a quick reminder that Injury Insider is brought to you by my very own blog and podcast, Status Life with Lita, and by the law office of Derek M. Hayes. Injured in Georgia? Make the right call to the law office of Derek M. Hayes at 404-777-HURT. This is one of my favorite topics, and you've done this show multiple times, correct?
Twice. This will be the third.
Twice back in the notes. All right. So I'm going to let you introduce the show.
Well, I was looking for a topic, as always, to start the day, and ultimately, I had a question that a listener had submitted regarding a crazy lawsuit that I'd referenced in a prior podcast. And the reason why it was referenced in the email to me is because an actual outcome has been published in this case.
Recently,
correct, in the last week or so. And it's back in the forefront of the news, and that's why the listener sent me an email saying, hey, you covered this on a prior podcast. I didn't know if you saw this or not, and I did. But ultimately, it was about a lady who contracted an STD in a vehicle when having unprotected sex with a gentleman. And ultimately, she presented a claim against Geico as the insurance company for the vehicle, claiming that she had been injured in the confines of the vehicle, and she was seeking compensation for medical bills, pain and suffering, and for the STD that she contracted.
So last time we spoke about this, was it still in litigation?
Yes. In fact, the facts, it occurred back in late 2017, and ultimately it just now came to resolution. And to kind of give you a little backstory on this, the couple had sex in this gentleman's car. It was in Missouri, and she contracted an STD. She presented the claim, as I said, to Geico, and they denied the claim, and their denial included the phrase that the damages claimed did not arise out of the normal use of the vehicle. So that was the basis for the denial. It's obviously not the normal use. They perceive the normal use to be driving down the road, going from point A to point B instead of having sex.
Yeah, but I remember when we did, we're all thinking, of course. Hello,
right.
This is her choice.
But here's where the law kind of takes a little bit different spin on this. You know, I've said before, common sense and the law don't jive. Sometimes common sense says one thing, but the law says something completely different. So in contract law, if you write a contract and I present that contract to you, I wrote it and I present it to you and you sign it, I sign it, it becomes a contract. But if there are terms in that contract that are vague or can be interpreted different ways, it's interpreted against the person that wrote the contract and in favor of the person who signed the contract but did not compose it. The theory is that if I compose the contract, it's a burden on me to make sure that the contract's written in such a way that there are no vague terms. There are no vague issues that would lead to litigation. Well, her argument was that the policy did cover it because the policy said that anyone in the vehicle was insured against his or her personal liability arising from his or her negligence and actions involving his automobile. So her theory was, and it's a very creative theory on behalf of her attorney, was she incurred the injury occurred inside the confines of the vehicle, and therefore, based on the language interpreted in the contract, it was covered. And ultimately, they filed a lawsuit. Both parties signed an arbitration agreement in March of 2021, and we've covered arbitration and mediation before. Mediation is where you go into the mediation and ultimately you're not bound by the outcome. You can leave and not settle the case if you don't agree with the last offer that was made, or if you're the insurance company and you're the one making the offer, if you're not willing to pay what they're demanding, you can walk away. But in arbitration, you sign away that right to walk away. You go to an arbitration and you're going to leave with an outcome. And the arbitration panel found that in favor of her, in favor of the lady, to the tune of $5.2 million against Geico. And again, they agreed with the theory that she was injured within the confines of the vehicle. Forget the normal use of the vehicle. She was injured, and therefore the policy required that they compensate her for her medical bills, her pain and suffering, and the STD itself, which was HPV, has lifelong effects.
It does.
But
I'm still speechless. I mean, I'm looking at you like they're $5.2 million because of a choice she made. I understand what you just said. I just can't wrap my head around it.
Well, going back even farther in the facts, initially she had offered to settle the claim for $1 million, and Geico refused to. That's why it went into litigation. Now, currently, Geico's appealed the federal case, and it's set for a jury trial in Kansas City in October of this year. They're trying to reverse the finding of their arbitration, which is going to be very difficult because they signed their arbitration agreement. So they're arguing technicalities to try and have the entire 5.2 outcome thrown out.
Well, that was going to be my next question. Is there the right to appeal here, right? If you have a jury trial and you don't like the outcome, you can make an appeal. Only a technicality in arbitration.
Correct. They're going to argue that the arbitrator misinterpreted the language of the contract, and therefore they aren't bound to pay anything since it wasn't the, quote, normal use of the vehicle. So that's their argument.
I hope they don't. I think this, I don't know.
So what do you think? Do you think she deserves to be compensated?
No, not at all.
Forget
not
the amount.
At all. No,
not a penny. Okay.
Not at all.
And most
I could
people
see
would say
her
it
going
that way.
after him. I don't know how that works. Maybe you call it civilly. He carried an STD. He gave this to her. He didn't tell her, obviously, that he had this. There's some negligence on his part. Why does that have anything to do with Geico?
Because she was injured in
She's
the confines
going
of the
after.
vehicle.
It doesn't matter.
I'm just
Could have
telling
been
you.
in a bed.
Right. I'm just
right.
telling-
How many? Can't they prove? Was this the only time they had ever done it? That's ridiculous.
I'm just telling you what the law.
It could have been on a park bench. Does that mean that the state, if it was a state park, needed to pay because she made a choice? No.
Again, the law looks at it this way, and very simply, he is covered as the owner of the vehicle through his insurance policy for anything that happens while in the confines of his vehicle.
I understand that.
And so when she presented a claim, you said against him, even if she sued him, Geico's responsibility is to defend him because it's in the confines of the car. So that's why when she sued him, Geico provided the defense attorney and would ultimately pay whatever verdict there may be, or in this case, arbitration. And ultimately, Geico, because of the poorly written contract, which is on Geico, not on her, not on him. He didn't write his own policy of insurance. She didn't write his policy of insurance. Geico did. So what's likely going to come from this is Geico and every other insurance company out there, they're going to have to tweak the language of the contract and be more specific and potentially define what normal use of the vehicle really means.
Sure, I understand that moving forward. That's the first thing they're going to do is leave that arbitration and hand it to their attorneys and say, you need to make this ironclad. Do I think she needs to be compensated? Absolutely not. I think even $1 million. I just do. I think it's a technicality, and I hope that they're able to prove something and not give her anything.
I don't disagree with you on that.
That's just my opinion,
right?
obviously.
In the sense that she consented to the unprotected sex.
Correct.
And ultimately, there are also two defenses that could have been raised. Assumption of the risk is one. You assume the risk when you put yourself in a hazardous or dangerous position. Forget the consensual sex. Think about this. If I get in the vehicle with someone who's drunk.
Right.
And I know they're drunk, and I've been drinking with them all day, and we're injured in a car wreck, and I'm very badly hurt, assumption of the risk is a defense against my claim against them because I knew or should have known they were intoxicated, and I assumed the risk by getting in the vehicle with them. So, again, there are things there that potentially weren't used that could have been used from Geico's standpoint, but after all said and done, there's an arbitration panel that awarded her $5.2 million, and it's now leading to a federal case, a federal trial in October of this year to figure out what's going to happen.
Okay, so it's not over.
No, it's not over.
They're not just going to cut that check.
And what may happen, just kind of on a side note as attorneys, what may happen is the defense attorneys for Geico may reach out to the plaintiff's attorneys, the attorney for the lady, and say, look, you've got a 5.2 arbitration award. We're set for trial in October. If this gets reversed, you're back to zero.
Right.
But we'll offer you X number of dollars to go ahead and make this go away. It may be $1 million. It may be $2 million. It may be $500,000. So it's some dollar amount.
Clarify for me. I'm sorry. The trial, is this going to go to a jury trial or a trial with just a judge?
It is set for a jury trial.
Jury trial. Okay.
Correct. And so, again, there'll be limited testimony of what's going to be admissible. There's basically nothing that'll come from their arbitration that'll be admissible, but they will have to talk about the contract language, I'm sure, and whether or not it's interpreted to mean something other than driving the vehicle and being injured while driving the vehicle. So if I'm sitting in the car with you and we're minding our own business, we're just sitting in a parking lot, and somebody comes flying through the parking lot and they hit the car, we're just sitting and chatting, and I get injured in your car, and that person that hit us has no insurance, I'm allowed to present a claim against your insurance coverage, your uninsured motorist, because I'm in your car and I was injured while in your car. So that's the extension of the argument that goes to the unprotected sex and the fact she contracted the STD while in his vehicle.
I hope that jury hears it and has the same reaction that I have. And it's not I don't feel for this girl. I mean, that's a horrible thing to happen. You know, HPV, like you said, there's lasting consequences to that, to a female physically. I think it's too much. I think it's too extensive, and I don't think Geico is at fault. I think it could have happened anywhere, and it's a technicality it was in that car.
Sure.
That's just my opinion, but I hope that the jury sort of thinks like me, because it just takes one or two, right? Mm-hmm. You have to get all 12 to agree, and if a couple, have my mentality, it's just my opinion. So
sure.
Anyway.
Well, it's one of those cases that's likely going to be talked about for a very long time.
Okay. And it's not over. So you're going to have to keep us updated.
And we as plaintiffs' attorneys are going to use the argument in other ways. I mean, obviously this was about unprotected sex and a STD, but there are lots of other situations, crazy examples you could come up with how you could be injured in a car that may lead to a claim, a valid claim.
I'm surprised you don't have more cases like that. Not just in a car, not this crazy lawsuit, specifically what we're talking about, but that just seems like a common occurrence. And you're a personal injury attorney.
And it could very well be now.
Again,
that's you think about the we covered in a prior podcast Stella Liebeck and the McDonald's hot coffee verdict and how that was perceived by the general public and the way the media presented it. I'm curious to see how this one eventually gets presented. But there are all kinds of cases that could come from what happened here. But again, I guarantee you every insurance company out there is scrambling right now to figure out how to fix the language in their contract.
I bet. Yeah, all the insurance companies are going to use this as their model.
Are they going to put warning labels now on cars? If you have unprotected sex within the confines of this car, it's not covered by any insurance policy.
Put that on the visor.
Yeah. You have to sign a consent form. I don't know.
Oh, my gosh. Well, a fascinating case. Again, keep us posted. Let us know what ends up coming out of the jury trial. But you've got some other pretty wild cases that we're going to discuss today.
Yes. And I, of course, led with that one because that was where the question came from.
All I know is this is called the trapped burglar. And you purposely did not tell me anything about this case prior to the show. So I'm hearing this along with everyone else.
Well, I haven't told you about any of these other than, of course, the one we talked about already, the Geico case. We discussed that in the prior crazy lawsuit, but I went with a theme when you said that you didn't understand why Geico was paying the money. And again, we talked about common sense and the law don't really go together. This next one is one where attorneys, including myself, will look at it and go, what the heck was a jury thinking? And I'll preface it by saying that. So yes, it's called the trap burglar. So this guy named Terrence Dickinson, he broke into someone's home. Okay, so by definition, he's a burglar. He's broken the law. He broke into somebody's home with the intention of robbing the house. The people are gone. He breaks in. Once he got inside the garage, he realized the doors were all locked and he couldn't get out. So he's trapped in the garage. Okay, he's breaking in to rob the house. He gets trapped in the garage.
Good.
The automatic door, the garage door wasn't working, so there was no way for him to get out. Well, the rest of the story. So the homeowners were out of town. They're on vacation. They didn't come home for a week. So for an entire week, Terrence Dickinson was trapped in their garage 1 week. So what do you do when you're trapped in a garage? Well, Terrence lived off of dog food and Pepsi.
Oh, my
That's what was in the
goodness.
garage. So Mr. Dickinson, who broke in with the intention of robbing the home, gets trapped, eats dog food and Pepsi for a week. When the family came home 8 days later, they found him in the garage. Well, he got arrested, as he should, but Mr. Dickinson sued the homeowners. And he sued them because he was trapped in the garage for 8 days and ate dog food and drank Pepsi.
That is ridiculous.
Well,
that an
yes.
attorney would even accept this as a case.
Well, I don't know whether or not an attorney handled this or Mr. Dickinson did.
That's true. I'm making that
probably
assumption.
was an attorney, just to be clear, but the court actually found in favor of Mr. Dickinson.
No, they did not.
To the tune of $500,000. Yes. Yes.
He
and as an
put
attorney.
himself in that position.
Yes. Yes. You remember we talked about assumption of the risk earlier? Well, when you break into someone's home, you assume the risk. Something bad's probably or potentially going to happen.
It also happens when you have sex in the backseat of
Well,
somebody's
yes,
car
yes.
and they have an STD. Like, hello,
Yeah.
people.
But Mr. Dickinson wound up with $500,000.
No, he did not.
Yes, he did.
Please tell me they appealed this or something.
From what I've gathered, based on my research, it ended with a $500,000 verdict. So $5.2 million for the first one who had sex in a car and got an STD, and $500,000 for a guy who was trapped in a garage for 8 days and ate dog food and drank Pepsi and got $500,000.
Why?
Even though he broke in
I know.
to
Tell me
commit
why.
a criminal
Tell
act.
me why, because I don't understand.
I don't either. And again, as an attorney, I read that and my mouth drops to the floor, and I don't get it. It just does not legally make any sense at all. They could argue that, so what we call man traps are illegal. A man trap would be if someone rigged a gun. So if somebody opens the front door and when the doorknob turns, the gun fires at the door. That's called a man trap. They're not legal. And so maybe they argued that the garage where the door didn't work and he got locked in and no way to get out was a man trap. But that's a stretch.
That is a stretch.
That is a stretch. And that's the only thing I can
he just happened
figure.
to be in the garage. He could have gone out a window, the whole
Sure.
thing.
He's committing
There's
a criminal
no
act.
way.
I
He got
agreed.
arrested. He's clearly in the wrong.
I agree. That's why it made the show. Again, I'm going with this theme of what?
Okay, please do a little more research.
I'll see if I can find anything more out about where it was, what state, and what year, and also, too, more importantly, what the final outcome was. But even if it was a $500,000 verdict and an insurance company assumed, of course, a homeowner's policy refused to pay it, I'm sure they negotiated down from that and paid something to make it go away. But a jury awarded him $500,000.
12 people.
Yeah, apparently. Could have been a 6-person jury. Okay, but either way, at least 6 or potentially 12 people gave him $500,000. Now, there's another one, the next one.
Oh.
Are you ready for another shock?
Dun, dun, dun.
So
All right.
this one is the botched suicide in New York City.
What?
Okay, now get ready.
Okay.
So a lady wanted to kill herself. Unfortunately,
gosh.
horrible things going on in her life, and she decided to take her life. And so to do so, she went to the subway, and she laid down on the train tracks on the New York City subway.
Okay.
Okay, her plan was to get run over by a train and die. That's what she wanted to do. Well, the train came along, and the train did run over her.
Oh, my gosh.
But it didn't kill her. Somehow, some way, she survived with very serious injuries, but she lived. She lived. And then guess what she did?
She sued somebody.
She
'cause
sued
she's
the
on
city
our
of New
show
York.
here.
She sued the city of New York. And what's even more shocking than that, the court found in her favor, and they awarded her $14.1 million for her injuries. Yeah.
I'm completely speechless.
Again, this
Producer
is one
Mike
of
is
those.
over there shaking his head.
Yeah.
Like, we're blown away right now.
So as an attorney, again, I'm listening to this, and okay, I can see how you could argue that, there was hazard, the fact that she could actually get onto the tracks and easily accessible to the tracks and all those things. But even still, she made a conscious decision to go lay down on the train tracks to, unfortunately, kill herself. And because it didn't work, because she still got run over by the train and survived with horrible injuries, she had the audacity to sue the city for her injuries and wound up with $14.1 million.
I am blown away.
Yeah, you should be.
I mean,
anybody should be.
okay.
Yeah.
What are people thinking?
I look at this again as an attorney, and I'm always looking at this from the eyes of someone who would represent someone who's been injured. And for the life of me, I can't figure out why a jury would have awarded money when your intent was to kill yourself. And ultimately, you put yourself there.
Right. That was your
you pay
choice.
The price for
the
what
same
you did.
thing as the robber.
Exactly.
That was your choice.
Or the
to be
STD
a burglar,
in the back of the car.
To go into these people's home and take their belongings.
Sure.
And accidentally get locked in.
And she committed criminal trespass by getting on the train tracks.
Yeah, they should have resued her.
That's a criminal act in and of itself.
I mean, that poor train conductor.
Yeah. Well, anyway, again, one of those that just doesn't make sense. You look at it and think, well, there
Crazy
you go.
Lawsuits. That's the name of the show. To this show.
Yeah.
All right. You've got more.
Yes, I do.
All right.
The next one we call the missing doorknob. So a guy by the name of Cedric McCarr was working in a building in the city as a claims examiner. He was taking a break, went to the restroom. When he got in the restroom, he got stuck inside. The doorknob on the inside was missing. So if you imagine opening the door, going into the bathroom, and the door handle on the other side to get out of the bathroom is missing. So he took his thumb and he stuck his thumb inside the hole where the doorknob would have been. Mm-hmm. And he was trying to use his thumb to turn the latch mechanism to pull the door open. Well, at the same time, somebody was on the other side, and of course he had no way of knowing, and they turned the door handle. So his thumb is stuck in there. They turned the door handle, and it caused severe injury to his thumb. So when it caused the injury to his thumb, he wound up having tendon damage and surgeries and, fixed the thumb.
Yeah.
But he was awarded $3 million for the injury after he sued the company that was responsible for the building, a company by the name of Newmark Realty. He was out of work for 6 months. He had to have the surgery, like we said, his medical cost, and they did allege he had a permanent injury. So he wound up with $3 million for sticking his thumb in the door to try and turn the handle to get out. Well, in addition to that, his wife was awarded $750,000 for loss of consortium, which the loss of consortium is the loss of spousal services because he was injured and his thumb was messed up.
Oh, my
he could no longer
goodness.
perform his spousal duties, cooking, cleaning, carrying the kids to and from
I
school.
mean, I'm laughing at this case. I mean, if you have a real loss of consortium claim in life, I'm sorry, and I'm not laughing at you, but this is ridiculous.
But on some level, this one makes more sense.
It does, and I was thinking that as you were going through it,
Right.
and I'm listening to you, like, okay, that is a real injury. It was a freak accident. An accident, that's the
Yes,
word. These
yes.
others were not accidents.
Right,
it was
right.
on purpose. You should not be awarded anything, let alone millions of dollars.
Yeah. So he's trapped in a bathroom and decides to try and use his thumb to get out, and lo and behold, $3 million later and $750,000 later for his wife, he's out the door, but
Wow.
he's got a messed up thumb.
Wow.
So yeah,
I might be okay with that one.
you
Want to take my thumb?
Yeah, I know.
Don't even take it off.
Yeah.
Just mess it up a little bit.
$3 million
$3 million
for a thumb.
I don't know.
It's kind of enticing.
I
little
gave a
bit.
kidney for nothing.
Well,
so
yes, you did.
I don't
That's
know.
right.
I mean,
You could have held out a little bit. Maybe.
woo. Yep. All right, keep going here. These
So
are
the
fun.
next one is a man in the phone booth. Now this one was made famous.
No.
President Reagan at the time. This happened in the mid '80s. President Reagan made an example out of this case in a speech regarding what he called, out of control lawsuits, litigious society, and used this as an example of a bad lawsuit. But in reality, when you hear the facts, it's kind of like Stella Liebeck in the coffee verdict. It makes sense. But I brought this one in because it does. When you hear the facts, you think, okay, that's a little bit nutty. And the fact that President Reagan made a big example out of it. But anyway, it was the mid-1980s. A guy by the name of Charles Bigby, he had gone to use a phone booth. Now, the phone booth, and we don't have phone booths really many places anymore. We all have cell phones. But the phone booth was in a bad position. It was next to a street and by a bar and a liquor store. So if you imagine a street that goes right next to this, and almost the way it's described, the phone booth sits between two streets. So there's cars going by on both sides of the phone booth, and there's also a liquor store apparently right there as well. So Mr. Bigby goes into the phone booth, makes his call. He's getting ready to get out of the phone booth, and as he's turning to get out, he saw a car coming right at him in the phone booth.
Right.
So he tries to get out of the phone booth. Well, the phone booth door stuck.
Oh, no.
And he couldn't get out. So the guy driving was a drunk driver, and the drunk driver wound up going over the curb and hitting the phone booth. So he was able to collect $25,000, which was the insurance coverage for the car that hit him. But he also went after the phone company that installed the phone booth and wound up with several $1 million.
Okay.
Now, you think about that and you think, okay, the guy's scrambling really quickly trying to open the door, panicking, a car's coming right at him. How can you blame the phone company? Well, in reality, the facts showed that the phone booth was placed at a dangerous corner, and they replaced it there after it had happened 2 years before and one other time besides that.
Jeez.
So he was now the third person that had been in a phone booth that had been struck at that same exact spot, but yet they continued to put it there. They also showed that the prior phone booth had problems with the door as well. So this was an example of 3 times a phone booth's been hit, and at least twice where someone was trapped in the phone booth and wound up, obviously suffering injuries when somebody went over the curb and hit it. So, again, the severity of the injuries, though, this guy lost a leg in the crash.
Wow.
So the injuries themselves were significant.
Mm-hmm.
The facts when you heard, okay, he's got $25,000 from the driver, how could the phone company be responsible? That's a stretch. But in reality, it made sense. So this case was used as an example of a litigious society and out-of-control lawsuits. But kind of like Stella Lieback, when you hear the rest of the facts, you go, wait a minute, that does make sense.
That's why I want to hear the rest of the facts on that robber.
Yeah,
okay,
something
that's
sounds
your
like
homework,
it's missing.
right? Because again, it sounds absolutely ridiculous, and there's no way.
Well, I'll also say too, that case, the one in the phone booth, it was taken up all the way to the California Supreme Court. It happened in California, and it was 12 years between when the case originated till the time the verdict was finally handed down. So that case was in litigation for 12 years over a phone booth and a guy getting trapped in there and hit by a drunk driver.
Wow.
So it takes a while.
I didn't realize it could possibly take that long. I thought criminal cases could take that long.
Well, the appeals that are available on whether it's criminal or civil, and I'm sure multiple motions that were filed through the course of the litigation. So anyway, that was how that one ended.
Okay. All right. So we're moving on to one. You've got all I can see is the title here, and you're going to tell us about the case.
Yes.
CBS sued by Bret Michaels, lead singer of Poison.
All right. Most everybody knows who Bret Michaels is.
Of course.
Okay.
Woo.
So CBS hosted the Tony Awards. Now, Tony Awards are for Broadway.
Right.
I don't know why Bret Michaels was there. Maybe he wrote some songs for a show or something. But anyway, he was there at the Tony Awards. It was broadcast in 2009. As he was leaving the stage, he claims that he was not properly instructed on how to leave the stage. You get your award or you do your presentation, you turn and walk off. Well, as he was leaving, he hit his head on a set piece that was hanging down pretty low.
Okay.
So he's walking off the stage. He wound up hitting his head. Neil Patrick Harris was the host of the Tony Awards again in 2009. And he jokingly said something about Michaels taking the phrase headbanger to a new level. So everybody laughed about it. It became a big joke. But in reality, he broke his nose, and he also suffered a brain hemorrhage that happened a few months later that was directly linked to the spot on his head, the blow to the head, when he hit this low-hanging piece of equipment. So broke his nose and wound up with a brain hemorrhage. So they claimed that it was caused by the piece of material or the piece of equipment that was there. And the courts ruled in his favor, and the amount of the award was never disclosed. So he's on the stage. He turns to walk away, and again, you think about what was in his line of sight. Was it the lights that blinded him from the stage? Was it dark, and he couldn't see? But somehow, some way, he walked right into something that was hanging down, banged his head bad enough to break his nose, and cause a brain hemorrhage.
I mean, I've been a performer my entire life. And yes, all you can see is bright light in your face. And when you turn, you're going into the dark wings where the curtains are. I mean, I can just envision it, and I really feel bad for him.
Well, anyway, a lot of people probably didn't know about that, but that was Bret Michaels. And, he did sue CBS and wound up with an undisclosed amount.
I had no idea, and I'm a fan of his.
Yeah.
But I thought he had, and this doesn't sound like it's relevant to the case, but I thought he had some pre-existing health conditions.
He's diabetic or something.
That's what I was going to say. He did a reality show and really talked openly about it. So when you started talking about this, I thought, well, geez, I wonder if something really happened that was related, but no, it was an injury.
Yeah.
And I feel really bad for him.
Right. And again, this is one that makes more sense.
It does, because it was an accident.
But I threw it in here because everybody knows who Bret Michaels is and probably did not know about what happened. You know, you may have watched the show that year and you may have heard Neil Patrick Harris make a joke out of it and everybody thought it was funny, but you may not have known what the eventual outcome
something
was.
really happened.
Yeah.
There's always more to the story.
Yep.
That should be the lesson, the takeaway from today's show here on Injury Insider. All right. I want to know about this one. Don't sue Summer.
This is truly one of those crazy
Is this
lawsuits.
a crazy one?
Yeah. This one was eventually dismissed, but I have to tell you because it blew my mind when I read about it. So it was the summer of 2019. Hadn't been that long ago. 2 women sued a water park for injuries they sustained when they broke in at night. So they broke into the water park, 2 ladies, and they sustained injuries while they were in there. In other words, again, they committed a criminal act. Well, here's how they got injured. They decided to go down one of the slides that was dry. It's a water park. The slide is dry. The water's turned off at night. And so when they went down the slide or attempted to, they broke their legs. As in both women broke both of their legs. And the reason why they ran into a gate at the bottom of the slide.
Oh my goodness!
It's a water slide without water at night, closed, and they jumped on it and slid right into a gate at the bottom, and both wound up breaking their legs. I'm laughing, not because
I know, but it's so outrageous.
Yeah, again, you assume the risk of what happens.
Correct.
So it was. They claimed in their lawsuit that it was too easy to break into the water park. That it was an attractive nuisance. An attractive nuisance means that something is enticing to you and you see it, and it becomes a nuisance in that it draws people there. Now, an attractive nuisance is typically something you would argue about a child jumping in a neighbor's swimming pool that's not gated and has no fence around it. That's why you're required to have fences around swimming pools.
Do you remember the other crazy lawsuit show that we did, and you talked about the guy that hid? I don't know if it was SeaWorld, but they had the orcas.
Yeah, and he jumped in the pool with the orca.
I mean, is an orca an attractive nuisance?
They probably tried
to
argue that. They probably tried to argue it. But anyway, so they wound up claiming the water park was responsible, that they did not warn them about the proper use of the slide during park hours only, and that it was too easy to break in and too easy to get on the slide and slide down it and hit the gate and break both legs for both of them. But the case was eventually dismissed.
Okay,
as
good.
It should have been.
Yes.
But again, to me, it was a crazy lawsuit, the fact that they even thought they could and apparently did.
Wow. And apparently did. But it was dismissed. And that's the difference from this one and the ones that you led with that actually got big amounts from a jury.
Right, exactly. So I got one last one.
You do?
To wrap
are we saving the best for last, or do I get to vote on the most outrageous?
I'm going to ask what you think is the most outrageous, and also we'll get Mike on the mic as well and see what he thinks.
Put him on the spot.
Yeah, this one is Walmart, and the title of it, Walmart helps man save money on his hip replacement.
Okay.
So this guy in 2016 went into a Walmart, and he wanted a watermelon. And if you've ever been to a Walmart, and even grocery stores and Sam's and Costco, those kind of places, there's a massive cardboard box that watermelons, sometimes cantaloupes, those bigger fruits are in there.
Produce section.
And they're typically on a platform or maybe a pallet, a wooden pallet
usually.
That's sitting out there. So the watermelons were on in a large box sitting on a pallet in the middle of the produce section. So the 59-year-old man saw a watermelon he wanted. He tried to pull it out and couldn't, so he climbed up on the pallet and his foot got snagged in the pallet. And he fell. And when he fell, he broke his hip. So he sued Walmart for his broken hip, for the surgery and the extensive healing process and therapy, everything after the fact, and obviously blamed Walmart because the way that the watermelons were in the box, he had to get on that pallet to be able to get the watermelon out, and it was a dangerous situation and allowed his foot to get caught, and in doing so, it made him fall and twist. And so ultimately, he claimed that they acted negligently by not warning customers about the protruding pallet. They did, in the case of the lawsuit, they did subpoena some of the security footage around that area, and the security video footage showed other customers using that same pallet, and all of which were also tripping. So he was the one that got his foot stuck, tripped and fell and messed up his hip and wound up with a hip replacement. But that was the powerful evidence that the jury kind of hung their hat on, and guess how much he wound up with?
Millions.
Yes, $7.5 million was the outcome. So the video evidence where it showed other people climbing on the pallets to try and pull watermelons out and also tripping was his smoking gun, so to speak. And the fact that it also, too, caught his specific fall on camera. So you could see that he was truly just trying to get a watermelon out. He wasn't trying to create a situation where, oh, my foot got stuck. Oh, I fell. But it did lead to $7.5 million because of a watermelon display in the produce section.
This is one. I'm going to break it down here. My opinion, I understand it. I see it. At first, the first half that you were talking about, I thought, okay, here we go. It's outlandish. Come on, man. You've picked up a watermelon before. But then you sort of made his point for him when you started talking about what his argument was. And okay, so then now I'm sitting on the jury, right? I'm weighing the facts here. But $7.5 million, it just seems that verdict is so outlandish for what happened.
Sure.
You know?
And he was 59
what were
years
his
old.
medical bills?
Well, here's likely how that got calculated. We have what's known as a mortality table. The mortality table predicts the number of years you have left, whether you're male or female, based on your current age. So he's 59 years old. They looked at the mortality table, X number of years remaining in his life. He's likely still employed, again, a fact I'm assuming, but they would look at what his projected earnings would be over the rest of his adult life and even through retirement. You also factor in the severity of the injury. He had surgery, a hip replacement. I don't care who you are. It's never going to put you back to 100%. You've got a piece of equipment now that is what you rely on as opposed to the God-given bones that you had to have a hip that was in good shape. So he probably had an economist testify regarding the amount of future medical cost, therapies, but also, too, his loss of earning capacity. And, again, I can see how mathematically a jury could come up with a number that high. When you think about it, though, just in terms of, he messed up his hip and he got $7.5 million, it may seem a little crazy, but the evidence may have shown to the jury that was a very valid number to come back with and award him.
Okay.
All right.
There you go.
So we've done, 8?
Okay, so I've got them laid out here just by title. So we've got the first one. I don't know what we're going to call it, but it was the STD.
STD in a car. We'll
STD in a car. The next one is the trapped burglar.
In the garage.
Yes, the trapped burglar in the
garage.
Make them think it's another case. All right. STD in a car, trapped burglar, botched suicide in NYC, man in a phone booth.
The missing doorknob.
In the
bathroom.
Don't Sue Summer, the girls who broke into the water park, Brett Michaels, and Walmart watermelon hip replacement.
That's it.
All right. So which one
stands out? Well, let's do it two ways. Which one seems most logical for the outcome? And then which one
all right, let me do that
stands
one
out
first.
as it's just too crazy to believe?
Well, logical to me, number one would be Brett Michaels.
Okay.
Number two would be the thumb in the key or
Sure.
the thumb in the lock. Those,
right.
Because
you could justify
You could
those.
justify. They were true accidents.
Yes.
Okay. So those two I can take off the table. Missing doorknob and Brett Michaels. Very logical. The most outlandish, I am absolutely torn. I'll let Mike be my tiebreaker unless he has a whole different one. STD in a car and the trap burglar. I mean, those two to me just blow my mind on the sheer stupidity and that they actually got awarded a large verdict.
Yeah.
Okay.
I'm not disagreeing with any of that.
All right, Mike, will you weigh in here and give us another opinion since you've been here in the background listening to the show?
Just a couple items on the one that laid down in the subway trying to commit suicide.
Right.
That's crazy. $14.1 million.
There was negligent, and it was operator negligence because there was a 911 call that someone was laying on the tracks. They told the operator of the subway, so he went down to a caution speed. He was only going to 15 miles an hour because they knew somebody was on the track, and they sued that he should have actually had extreme caution and been maybe 10 miles slower. So he didn't stop in time.
Did you read that?
Yeah, I'm reading about the case.
Oh, he's got his computer. We don't have a computer in front of us.
So
okay.
So it was operator negligence,
Wow.
which is why she won the case.
Okay.
They said that the operator knew somebody was on the track, was going 15 miles per hour, but should have actually been going under 10 miles per hour. Had he been doing that, he would have been able to stop in time.
Wow.
But the craziness, though, still is the fact that she put herself in that position
Right.
for
Right.
the purpose of dying.
Right.
Just like the burglar in the garage
Yeah.
who actually sued for undue mental anguish. That's the one I pick. The
Okay.
burglar in the
Trap-
garage.
yep.
That's just
Yeah.
that's just stupid.
Yeah, it is.
They're all
It's
bad.
nutty. Yeah.
They are all
So which one to
outrageous
you sounds
lawsuits.
most logical?
Well, the Bret Michaels.
Yeah.
Yeah.
No
Yeah.
question.
I mean, you break your nose on something in the dark.
Yeah, I've
I
actually
mean-
seen the video.
Oh,
so.
really?
Oh, you have?
Yeah,
Ah.
yeah.
Oh, wow. Okay. That's the first I've heard of it. So I don't watch TV much, so I'm too busy podcasting.
Yeah, exactly.
All right. Well, a fantastic show. These are one of my favorites. But Derek, you take listener questions, and not just here on the podcast, but you have a way on your website that anyone out there that has been injured, if they have questions for you, a potential case, they need your expertise, I'm going to turn it over to you. Tell everyone how they can find you and reach you.
Yeah, absolutely. Well, go to my website. That's always the starting point. It's Derek, D-E-R-E-K, the letter M as in Matthew, and then Hayes, H-A-Y-S. So DerekMHayes.com. On my website, you'll see a podcast tab. You can click that, listen to any of the prior podcasts, but also, too, submit a question or a potential topic. I've had many, many questions and topics that have come into me that have turned into shows. In fact, today's kind of started from a point that was made by a listener about the prior crazy lawsuit. So anyway, yes, definitely reach out to me that way. Also on my website, you can learn a lot more about me, my law firm. You can send me a direct email about a potential claim. I will be the one to call you and discuss it with you. And if I can help you, I'll be happy to do so and discuss that with you. You can also check out my social media platforms. I'm on Instagram, also on Facebook and Twitter, the Law Office of Derek M. Hayes. So you can find me that way. My phone number's 404-777-HURT or 678-225-0970. And one final point, we did this today, and when I've done the other two Crazy Lawsuit podcasts, I've also asked people to respond.
Oh,
to
yeah.
reach out
Please
to me,
do.
vote. I will next podcast talk about which one won, if that's the word you want to
Right.
use, which one got the most votes. But yes, definitely reach out to me, make comments and suggestions, and I'd love to respond directly to those.
And if you guys know, like Mike did, he did his homework because he was curious as we're sitting here taping. If you find out any information on these that we did not air or broadcast and you want us to share some of the points, I'm most curious about that trap burglar.
Yes.
But anyway, and if you hear of some, if one has happened in your hometown and you want to share it with us, we'd be happy to put it on the show. These are absolutely fun. Takes us away from sort of the seriousness of the law that we do on this show so many times.
I got one question for you.
Yeah.
Would you live 8 days in a garage on Pepsi and dog food for $500,000?
Yes.
That's a tough question.
No, you wouldn't have a choice. I was locked in.
Yeah, well-
there's no choice.
Okay.
I mean, do I want to eat dog food? No. But if I'm locked, I mean, think how hot, maybe, I don't know. I'm assuming because it's 100 degrees outside here today, but it could have been hot in there. I don't know. But yeah, if I'm trapped, I'm going to,
I'll eat whatever I can find in there.
you're
Right. Exactly.
You gotta do whatever you can do. All right. Thank you so much for joining us on Injury Insider with Derek Hayes, presented by Status Life with Lita and the Law Office of Derek M. Hayes. Don't forget that you can enjoy any of these episodes anytime by visiting businessradiox.com, selecting the Gwinnett Studio, and then clicking on Injury Insider with Derek Hayes. This program is also available on Apple iTunes, iHeartRadio, Spotify, or wherever you can listen to your favorite podcasts. Until next time, for Derek Hayes, I'm Lita Brooks, and you've been listening to Injury Insider on Business Radio X.